Good day, sir. My name is Cadiente, Section D, and this is my answer to the questions for the final exam of CLG 401. So, number one question is, who must prosecute the criminal case actions under the latest amendments of to Section 5, Rule 110. So, all criminal actions shall be prosecuted under the direction and control of a public prosecutor. In case of heavy work schedule of the public prosecutor or in the event of lack of public prosecutors, the private prosecutors may be authorized in writing by the chief of the prosecution office or the regional state prosecutor to prosecute the case subject to the approval of the court. Then, number two, when is a complaint or information deemed sufficient? So, a complaint and information is sufficient if it states the name of the accused, the designation of the offense, the acts of omission complaint, then the approximate date of the commission of the offense, and the place where the offense was committed. Number three, what are the elements of prejudicial questions? So the elements of prejudicial questions are, number one is the previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action. And number two, the resolution of such issue determines whether or not the criminal action may proceed. Then number four, define preliminary investigation. When is it required? So, preliminary investigation is an inquiry or proceeding determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for a trial. Then, a preliminary investigation is required to be conducted before the filing of complaint or information for an offense where the penalty prescribed by law as at least 4 years or 4 years, 2 months, and 1 day without regard fine. Then number five, what is inquest investigation? So, an inquest investigation is an informal or a summary investigation conducted by the public prosecutor in a criminal case involving the person arrested, detained without a benefit of a warrant of arrest issued by the court for the purpose of determining whether said person should remain under the custody of corresponding charge in court. Then number six, define arrest. How is it made? So arrest is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. Number seven, what are the instances when arrest without a warrant is lawful? So these are the instances of an arrest without a warrant, and it will be without a warrant that is lawful. So there are three. So one is when in his presence the persons to be arrested is actually committing or is attempting to commit an offense. Number two, when an offense has just been committed and he has probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it. Then, number three, when the person to be arrested is a prisoner who has escaped from a penal establishment or a place where he is serving his final judgment or is temporarily confined while his case is pending or has escaped while being transferred from one confinement to another. Number eight, so, narata sa number 8, no? So, what is bail and what are kinds of bail? So, bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the condition hereinafter specified, no? So, bail may be given in the form of corporate, surety, property bond, cash deposit, or recognizance. Then, number 9. So, number 9, give 5 rights of accused. So, these are the rights that I've choose. So, to be presumed innocent until the contrary is proved beyond reasonable doubt. Then, next is to be informed of the nature and cause of accusations against him. To be exempt from being compelled to be a witness against himself. Then, next is to have speedy, impartial, and public trial. To appeal in all cases allowed in the manner prescribed by law. So, number 10, how is arraignment made? So, the arraignment which shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information reading the same language or dialect known to him and asking him whether he pleads guilty or not guilty. So, number 11, what is plea bargaining? So, a plea bargaining is an arrangement between a prosecutor and defendant whereby the defendant pleads guilty to lesser charge in anticipation of leniency. Number 12, what are the instances when an arraignment may be suspended? So, these are the instances. So, the accused appears to be suffering from an unsound mental condition which effectively renders him unable to fully understand the charge against him. Then there's excess prejudicial questions. Then a petition for review of the resolution of the prosecutor pending either the Department of Justice of the office president. Then number 13, when does double jeopardy attaches? So double jeopardy attaches when the jury is sworn, when the first witness is sworn, when the court first hears evidence in juvenile proceedings, or when the court accepts a plea agreement between the defendant and prosecutor. So, number 14, what is the order of trial in criminal cases? So, number 1 is the order of trial in criminal cases. So, first is the prosecution shall present evidence to prove the charge, and in the proper case, the civil liability. The next, the accused may present evidence to prove his defense and damages, if any arising from the issuance of the official remedy in the case. The next is the prosecution and the defense may, in that order, present rebuttal and rebuttal evidence, unless the court, in furtherance of justice, permits that to present additional evidence bearing upon the issue. So, number 15, when can a co-accused be discharged to become a state witness? So, from what I've sa section 18, discharge of accused for acquittal, it's the order indicated in the preceding section that it shall amount to an acquittal of the discharged accused shall be a bar to future prosecution for the same offense unless the accused fails or refuses to testify against co-accused in accordance with his sworn statement constituting the basis of his discharge. Number 16, define judgment. So, judgments is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him or the proper penalty and civil liability. So, number 17, define search warrant. So, a search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, and commanding him to search for personal property. Then, next is 18. What are the requisites in order that a search warrant to be issued? So, a search warrant shall not issue except upon a probable cause in connection with one specific offense. No? Probable cause. It shall not issue except upon a probable cause. So, probable cause is very important in order to issue a search warrant. So, offense to be determined by judgment examination under oath affirmation to the complaint and witness he may be proceed in a particular describing the place or search and things to be seized anywhere in the Philippines. What are the personal properties subject to search and seizure? So, the personal properties that to be subject for search and seizures are these are the subject of the offense, stolen or embezzled, and other proceeds or fruits of the offense, used or intended be used as the means of committing an offense. So, lastly, last number, what are the qualification of a witness? So, a qualification of a witness is that a witness is a person who can perceive and perceiving can make known their perception to others. Maybe he can be a witness. So, religious or political belief, interest in the outcome of the case, or conviction, crime, unless otherwise provided by law, shall not be ground or conclusion. That's all, sir. Thank you.